Welcome. All right. Can we go next slide, please? Okay, so I just give everyone an introduction here. Jason, do you want to introduce yourself?
Yeah, my name is Jason Addlestone. I'm a senior associate with Vicente LLP. I have been with the firm for just over about 6.5 years now, specializing in federal international policy and co-lead that practice group with Sean Hauser.
I'll introduce myself. I'm Charlie Alvacetti. I'm based outside DC, the single member of our Vicente, Maryland office. I run the corporate group, and I've worked on a number of these 280 opinions, which is sort of my connection to this topic. Sean?
Thanks. I'm Sean Hauser, one of the partners in the Vicente Denver office, and lead the federal and international law practice with Jason, where we've been focusing significantly on rescheduling over the past few years, and also co-chair the hemp and cannabinoids practice.
Jesse.
I'm Jesse
Grew a
Hubers.
beard.
Yeah, I'm Jesse Hubers with HBK CPAs. We're a CPA firm that provides accounting and tax services. I lead the tax practice for our Cannabis Solutions group. So we'll help carry out some of the tax planning that law firms like Vicente will talk about in this presentation.
Thanks. And Charles.
Hello, Charles Warren. I'm with Jones and Keller, but work a lot with Vicente and do transactional tax work and also 280E tax planning.
And next slide, please. Thanks, everyone. So this is the overview of what we're going to talk about. And just if you have a question you want me to ask, please pop it into the webinar chat. A lot of this is going to be sort of me asking the tax professionals on the webinar the kinds of questions that we get asked by clients all the time. So if you have an issue you want to sort of kind of hash out here, please let me know and I can add it. So we're going to start off by talking about rescheduling, the timeline of rescheduling, potential litigation, the presidential election, and how that's going to impact 280E and tax planning. And then we'll talk about tax strategies, pros and cons of different approaches to 280E. And then, if we've got extra time, Charles and Jesse talk about some of the sort of the nitty-gritty tax nuances you need to think about as a result of rescheduling, as well as the nitty-gritty in terms of how companies are trying to address 280 right now. Next slide. And I'm going to turn it over to Sean.
Thanks, Charlie. So we're, well along in the process, which is exciting, and I'll go over kind of what we can expect after the election. But essentially, we are in the hearing stage of this administrative process, which has indeed moved expeditiously as President Biden ordered that it did. And the DEA did not have to schedule a hearing to consider whether marijuana does indeed have the medical use and abuse potential sufficient for Schedule 3, but they have decided to. They've scheduled that hearing for December 2nd. It will be an administrative law hearing, sort of like a mini trial, and where evidence can be presented on both sides, and all of that evidence will be considered in addition to the ULC memo, everything in public comment, and DEA's decision in potentially reclassifying cannabis. The hearing could be set for a number of days at their discretion. We are anticipating that we will know how many days the hearing will be in more details in the month of October, but we do not have that certainty yet. After the hearing concludes, the judge will gather all the evidence and then make the recommendation to the DEA. That process could also take some time, and that timeline is uncertain, and the election could factor into it, although much of this is really the DEA's timeline. And as I mentioned, the DEA will consider the FDA HHS recommendation, which was that cannabis does have, medical efficacy and a safety profile consistent with Schedule 3. And the Office of Legal Counsel's memorandum on rescheduling substantiating the same in depth. And the numerous comments submitted during the period, which were overwhelmingly in support of descheduling or rescheduling to 3, DEA's own review and analysis, and the record from the administrative hearing. So we can expect that the hearing will include those with, legitimate standing that would be, harmed in either scenario, Schedule 3 or remaining in Schedule 1. And once DEA makes its determination, they will issue a final rule by publishing it in the Federal Register. I expect that it's certainly not going to happen this year, but hopefully, we get a final rule, sometime in 2025. The final rule will become effective 30 days after it's published, and during that time, anyone with standing can seek judicial review. A lawsuit is almost certain in this process, given the stated opposition of Kevin Sabat and others who have, made clear that they are going to sue. But, there's a lot, including in the public comment and what's provided by HHS, substantial legal and medical and scientific evidence and legal grounds supporting Schedule 3. And I'll turn it over to Jason to add on that. I would say that, the election will certainly, be relevant here, and what happens after rescheduling, if it does go through, and of course, whether the process go through. This was a Biden initiated directive in October 2022. He ordered the agencies to expeditiously review whether marijuana belonged in Schedule 1 and to, end the harms of the failed war on drugs, and also worked with governors at the state level to issue pardons and, make sure that people that don't belong in prison should be released. Vice President Harris was also, as vice president, behind that initiative. It's very rare that a presidential administration makes that kind of directive. So this was, a strong position by the Biden-Harris administration on cannabis reform. And given that descheduling is pretty much an impossible scenario in this administrative process, because the FDA has to consider abuse potential and other factors that would preclude descheduling. This is, the optimal scenario in this process, and then the next step is descheduling, which Vice President Harris has been a longtime proponent of legalizing cannabis, adopting a federal regulatory framework, been a champion of legislation related to the same with the MORE Act. She's been on the campaign this week confirming that if elected, she'll break down the legal barriers that hold minorities back by legalizing marijuana and working with Congress on a federal regulatory framework. Walz has also been a longtime proponent of legalization and strong regulatory frameworks in his home state of Minnesota. And they've both been, proponents of many reform bills. Trump has also said recently in his campaign that he supports rescheduling and banking access, and that he will continue to focus on research to unlock medical uses, that he supports, the Florida legalization campaign. His prior administration had seen the election of folks like Jeff Sessions as Attorney General, where there was concern that would take back the federal government's non-enforcement policy. That didn't really happen, so it's unknown, what a Trump administration would do on this issue, given his past administration's position and his VP's position. But so far they've been consistent on the states' rights point. So, a lot of unknowns with the election. I think we do know we have a lot more certainty with the Harris administration, given the depth of involvement in this process. So I think, we'll have more predictions there post-election, of course. And I will turn it over to Jason to go through more of the process here.
Yeah, thanks, Sean. The only thing I'll add to that is I completely agree with the assessment on Harris campaign or Harris winning and Trump winning. I do just want to point out, while I don't think this would be much of an issue at all with if Harris wins, if Trump wins, again, we don't know who he's going to appoint as an attorney general or DEA administrator, and those two have an immense amount of power in this process. So even if Trump, having come out and said that he's in support of it, if the AG that's appointed or DEA administrator disagree, that could kind of change things. But going back to the hearing, it is scheduled for December 2nd. So as long as that's not postponed beyond that date, we expect that it will last about 2 to 10 days. This expectation is based on another DEA ALJ hearing that's set for November on psychedelic substances. But of course, because there's no, we don't really have too much information about this yet, that if the DEA decides to take a really open stance on this, it could last longer than the 10 days. As Sean said, final rule will not become effective until 2024 at the earliest. Most likely Q1, Q2 would be the earliest possible time that could happen. But because of litigation, that will certainly occur no matter if it's moved to Schedule 3, remains on 1, or moved to 2. Depending on if a court puts a stay on it, this could be delayed even longer, months to years. But I would expect that we would at least have some clarity at some point in 2025. And yeah, I will pass that on to, I guess, Charlie or whoever's next.
Thanks. Okay, can we go to the next slide? Yeah, so this is kind of a combination, right? So like as we just talked about, the actual effective date of 280E is an open question because we don't know the timeline yet. It's going to be 30 days after the final rule if there is no kind of injunction. So let's just play out a few scenarios to help everyone kind of understand, right? So let's say that the final rule is published 30 days. Let's just say 30 days post final rule is June 1st, 2025. How would that impact 280E? I guess Charles or Jesse, would you see it as the year would be a portion of the year? Everyone would be subject to 280E, and a portion of the year you would not be subject to 280E, but you would still file one tax filing?
Yeah, so I mean, absent like a legal argument you could make for retroactivity, it should be like a cutoff point because as soon as they reschedule it, you're no longer trafficking a Schedule 1 or 2 drug. But before that point, you're still legally trafficking.
Right, and I think that we're talking about that people expect there to be we would expect some IRS guidance on this, but obviously nothing's been
I'm
released
skeptical
yet.
that it would be helpful to taxpayers, but yeah, I think they would probably release some guidance. Probably not the guidance we'd like, but.
So yeah, I mean, I think that's one of the key points here about 280E, other than like the bifurcated tax year, right? Is that it's not going to be retroactive. So, it's also there's not going to be any forgiveness of past tax debt, past tax liabilities. So everyone should just, build that into their calculations right now. So kind of getting into kind of the heart of the controversial kind of questions here. Do you got, Charles and Jesse, I'll just call it the tax professionals. Do the tax professionals have any take on sort of, because there's been a lot of rumors flying around the industry right now, that you hear people talk about, because there's a couple of high profile companies, I won't mention any specific names, but a couple high profile companies have announced that they've gotten money related to amended tax returns. Obviously, I don't think the full story is out in the open. Even if you're a public company, you don't have to disclose every detail of what happened. So, do you guys have any views in terms of like, what are the rumors? What are the misconceptions?
Go ahead, Jess.
Yes. Go ahead, Charles.
No, go ahead.
Oh, okay. Yeah, no, I take those kind of anecdote stories with a grain of salt. With Trulieve, obviously we've got some concrete information there, but we don't really know what their tax position is. There's a lot of folks taking tax positions, a lot of law firms writing opinion letters on various tax positions. You hear a lot of people talking about taking the Trulieve position. That's largely just an assumption that you think you're taking the same position as Trulieve. So there might be more information there that we're not privy to, that kind of hints to why they got a refund. But in what I've seen, I haven't seen anybody get any money back. I've also not seen many people get audited yet on this point, but we haven't gotten very far into this process of everybody filing these tax returns based on these opinion letters. So I think it really remains to be seen what's going to happen. I'm telling clients I wouldn't expect to get money back by any stretch of the imagination. The IRS is saying we're not going to give you any money back. So I would take them at their word for that. As far as Trulieve, I have no explanation for how they made that happen.
I think one of the rumors was that Trulieve, a predominantly medical, if I understand, received the refund, but the IRS didn't publicly challenge or pursue any public proceedings in order to not give other cannabis operations an opportunity to know precisely what the challenge is. And then the IRS essentially has indicated that they continue to, or plan to continue to deem cannabis as Schedule 1. So I don't know if that's accurate, but it sounded quite reasonable to me when I first heard it, of how the IRS was approaching. So the retroactivity is going to be a significant issue. I think we'll get into it further, but a reasonable or responsible Congress would pass legislation, authorize regulations in order to advise taxpayers what will happen with respect to the transition, not short tax periods, but prorated tax periods, how prior transactions and basis will be properly treated, how to transition someone from no deductions virtually to deducting all typical expenses. Another example is what happens if you acquired a cannabis company in the past. So there's a lot of issues that are going to be open.
Yeah, I guess, and so it's certainly it's my understanding, right? None of this has yet to come up in tax court, right? I mean, it's all too new. So I mean, at least my take on the situation is that there's a lot of people, you hear a lot of people's viewpoints out there, but until you've seen how it plays out in tax court, it's really a lot of it is speculation.
Right. And I think if you've got, the risk tolerance and the finances to, pursue, opinion letter and some of these other things to take a position that, 280E doesn't apply to you. My thought is, don't worry so much about the money you've paid already, but let's try to keep as much of your money that you're already holding right now. And, with respect to some of these amended returns, I don't think you're going to file an amended return and get a check. But if you can file that amended return and apply it as a credit and keep some more of your money going forward, then the onus is on the IRS to get the money from you, right? You're not trying to get the money back from the IRS. So, I still think there's certainly, a lot we can do here, even if you're not expecting to get a check from the government. But you know, we're just going to have to see what happens.
And I guess to that, just to talk about the, you know, I guess, do you want to talk a little about these opinion letters that, you know, I guess we'll put that into like the bucket of rumors that are going around the industry right now? Like why would a company want an opinion letter related to 280E, and what do they do
Oh,
with
right.
it?
Yeah. So like from an accountant's perspective, like us, you know, we're filing tax returns for folks. You know, if someone's got a tax position that they want to take, you know, we're not going to want to put ourselves in peril just to, you know, take some tax position that's not, you know, there's not substantial authority for, you know, or that we have to come up with some sort of idea that there's reasonable basis for. So you can take a tax position that has a reasonable basis, which is, you know, some folks say is like 20% likelihood of success. I don't know that that number really is grounded in anything. If you adequately disclose it on a tax return by filing Form 8275, as an accounting firm, we don't like to, you know, make a determination as to whether or not there's a reasonable basis for a certain position. We feel like that's more, you know, for an attorney to determine. So we rely on opinion letters from attorneys to identify reasonable basis, and then we'll use that reasonable basis to disclose the position on the tax return, and then file accordingly. And so if we adequately disclose a position that there's reasonable basis for, then it protects the taxpayer from penalties if they ultimately get audited, you know, and lose either on appeal or in court.
Right, it protects the tax file preparer as well, right?
Yes.
Yeah, so I mean, that's just for everyone to understand, you know, that you know, if you're trying to take an aggressive position on your taxes, this is why your accountant might sort of insist that you get a legal opinion. Because the penalties could apply not only to the tax filer, but the tax preparer.
Yeah, and the penalty is, under the accuracy related penalties, 20% of an understatement, which could be significant accruing interest. So, and you know, the 20% standard actually came out of the Joint Committee on Taxation when they, I forget, but when they modified the accuracy related penalties. So there is some congressional authority for the 20% standard, and typical tax attorneys will kind of use that as a benchmark of some sort. I mean, it's loose, but yeah, if you have a reasonable basis and a tax opinion to that effect, then you have the ability to have some comfort that the 20% penalty would be abated or not brought by the IRS. So,
right, one thing that people, you know, in conversations with people that's been brought up is that, you know, people say, well, it may be that the IRS may not just sort of say, oh, you have an opinion, we're not going to apply the penalty. You may have to sort of fight with the IRS. It's not a guarantee that they're not going to press you.
correct.
Yeah, I certainly agree with that. But from both the taxpayer's perspective and from our perspective, you know, having, you know, an opinion letter from attorney who's, you know, their whole career is making these kind of legal determinations is a lot better evidence in you know, argument with the IRS than a, you know, CPA firm kind of coming up with our own conclusion and, you know, maybe writing a little memo about it. So I think it's just the best way to, you know, protect the accountant and the client.
And you know, we just got a question, which I think would, just to make sure clear for everyone. So the position being taken on 8275 is that 280E does not apply to the company. And just so everyone, you know, 280E says that, you know, if a company is trafficking a Schedule 1 or 2 substance within the trafficking a substance within the meaning of Schedule 1 or Schedule 2 of the Controlled Substances Act in violation of federal or state law, then they can't make these deductions. So yeah, you file your taxes as if 280 was inapplicable, right? Which obviously results in a far lower tax burden to the company. you know, of course, the question then becomes, well, how can you claim that, right? You know, without getting into the details on it, you know, there's a few arguments. I mean, there is a case right now that's being appealed, Canada provisions. It was dismissed, but it is being appealed. And if you look at that case, that gives you a number of the arguments that people are making right now in terms of, you know, whether this can be the current situation can be distinguished from the ruling in Raich. And that, you know, perhaps this is outside of Congress's powers, given that this is purely intrastate, and under the Constitution, Congress is really only supposed to regulate interstate commerce. It's obviously a lot more nuanced than that. But you know, there's a number of arguments that you can make that that the 280E is sort of, it's basically bad law, and that it will be, it's going to be reversed at some point when it's challenged, and you know, it will be retroactive. Now, again, you know, just to the earlier point about reasonable basis, nobody's saying that, you know, I'm going to bet all my money that that's actually going to happen, right? This is just that there's a reasonable basis to take that position. And to, you know, it's, again, this is, you're getting a 20% on a test. It's not a particularly high score. Did you guys want to talk about like what the IRS has said? Because I know that they've put something up on their website. Every time I've got a chance to ask someone on the panel, they give me their you know, official answer. And I know that there was an accountants meeting in Denver where an IRS, I think, counsel was there, who gave sort of a not so positive view of companies taking this position.
Yeah, I mean, to my knowledge, they're just broadly, you know, asserting publicly that cannabis remains on Schedule 1, and 280E disallows deductions for trafficking a Schedule 1 drug. So 280E applies to you if that's what you're doing. You know, and that, you know, all these folks that are filing amended returns should stop doing it. They're not going to win. You know, all the things you would expect them to say. You know, I take that with a grain of salt as well. I don't think it's a shoe-in by any means, but I don't think it's as you know, a shoe-out, for lack of a better term, as the IRS is acting like it is.
I guess, is there any, would it be more surprising if the IRS said something otherwise?
It would certainly be more surprising. Yeah.
Right. I mean, to me, again, as not as a tax professional, but you know, to me, it's like if you ask the DOJ, is cannabis federally legal? They're going to say, you know, of course not. It's a Schedule 1 substance or the Controlled Substances Act. It's illegal except in very narrow circumstances, right? So I just think, you know, they're not a body that makes law.
Yeah, and I think if you just even look at what the IRS is, you know, they don't you know, they don't even write the regulations. The Treasury does that. The IRS is a collections agency, right? So, you know, they're in the business of collecting revenue. So if there's a position, they're gonna fight for whatever's gonna generate more revenue. So that's generally what I would expect to hear from them.
All right, next slide. So let's just talk a little bit about, you know, knock wood. We're now in the world in which rescheduling has gone through. Cannabis is a Schedule 3 substance. What do you think is going to happen in terms of reorgs and restructurings of companies to become more tax efficient in a world he is no longer a concern?
I would think those that, and many of those that are currently operating under C Corp are going to want to analyze whether the C Corp structure is still the best organizational structure from a tax purposes on a go-forward basis, particularly with respect to future sales of assets or equity, in particular asset sales and the double tax that C Corps are subject to, one on the sale of assets and one on distributions of proceeds to shareholders. I mean, it gets complicated. If you're entitled to the 1202 qualified small business stock exception, you may want to stay as a C Corp. If you are not, you may want to be a pass-through, and therefore an LLC that doesn't elect C Corp status. So there's going to be a lot of analysis and planning in that respect. The problem is that if you liquidate a C Corp, whether it be by a true state level liquidation, an IRS check the box election to be a pass-through, that will be deemed a taxable liquidation event to both the company and the shareholders. So choice of entity is going to be an issue on a go-forward basis.
Yeah, and one other thing, just kind of following up on what Charles said. Right now, we've got this QBI deduction for pass-through entities, which is, really valuable outside of the cannabis space. But when we're looking at retail operators, where, just based on the way that the inventory rules work, no wages are inventoriable, and therefore no wages are deductible. And the QBI deduction has, once you kind of phase into higher levels of income, there's tests based on your W-2 wages, and you only get to include W-2 wages to the extent they're deductible. So currently, a lot of retail cannabis shops are, not eligible for the QBI deduction. And once, all of these wages become deductible, they also become usable for purposes of the W-2 wage test and the QBI deduction. And all of a sudden, this 20% off the top deduction becomes a lot more valuable for cannabis operators. So that should, kind of shift the scales a little bit more towards pass-through entities as well.
And so my understanding is that the Trump, the 2017 Trump tax cuts sunset in 2027.
Right.
So I guess that's another thing, right, which will depend on the outcome of the presidential election, right, in terms of entity choice. If we think that tax cut's not going to be renewed, is that going to impact people's choice, corp versus LLC?
Yeah, I'm sure it will. I think we've got two very different visions of what the tax code is going to look like over the next 4 years. It's going to depend on what Congress looks like as well. So I think there's a lot of unknowns in the current situation is really all I can get my arms around right now. And I think in the current situation, I could see a lot more folks shifting towards pass through. And I think just historically, that seems to be the entity of choice for most regular businesses, especially small businesses. I think we're going to obviously a lot of the larger businesses want to be C corporations. It works better for, venture capital, obviously public companies and everything like that.
How about section, the other big thing you hear a lot about in cannabis, right, is 471C, right?
Yeah. Good.
Oh, I was going to say, if you just talk a little bit about that, is this a solution? I think my understanding is that at a certain revenue number, you can't really rely on it anymore.
Yeah, so there's a gross receipts test. It's round about 30 million rolling average, 3-year rolling average. Once you're above that, then you can't use 471C. But 471C, makes sense if you think about what 280E actually does, right? So it disallows deductions and credits, and so a deduction is a component of taxable income, right? So gross income less deductions is taxable income. But what's not a deduction, the low-hanging fruit is cost of goods sold, right? So cost of goods sold is just a component of measuring gross income before you even get to a deduction. So the more costs that wouldn't otherwise be deductible that you can capitalize into inventory and then otherwise recover through cost of goods sold before you get to gross income, then less deductions are wasted, right? So you might not get to deduct them through this deductions bucket, But if you can move them up into the cost of goods sold bucket by capitalizing them into inventory, then you're not wasting all of these deductions. So we've got some pretty strict rules under 471A about what you can capitalize into inventory. And what 471C does is just expands those rules. So it says that a taxpayer's inventory method shall not be treated as failing to clearly reflect income if it either treats it as non-incidental supplies and materials, which has more to do with timing, or is conforms with the taxpayer's applicable financial statements if they have any, or if none, with their books and records. So their financial statements, if they're GAAP financials, typically are going to be the same as the normal inventory rules. Who can mostly benefit from this is taxpayers that are below that threshold and who also don't have applicable financial statements. So those taxpayers, basically whatever their books and records say, 471C says that, as long as for tax purposes, they're treating it the same way, their method shall not be treated as failing to clearly reflect income. So on its face, 471C says if you qualify for this method, whatever you do in your books and records, whatever you treat as being capitalized into inventory, we're not gonna fight you on it. The regulations came in and tried to, undercut that a little bit. But pushing that to side for a moment, what this allows you to do is theoretically taken to its fullest extent. You could just say, well, every cost I have is capitalized into inventory. And then every cost that all of these costs that are capitalized in inventory, I'm taking through cost of goods sold, and I'm not wasting any deductions. Our perspective is that that's pretty aggressive. I personally wouldn't sign a tax return that capitalized everything into inventory, but I think there's certainly some wiggle room here to capitalize a lot more into inventory than otherwise would be available under the regular 471A rules.
So, even if you're a cannabis company that was using 471C, you would still, in most cases, pay less taxes if you were trying to take one of these aggressive positions saying you weren't subject to 280E, unless you were trying to everything into
unless you were
COGS,
trying
right?
to capitalize everything in inventory.
Right.
Even if you did that, you would still pay more taxes in the current year, because if you're capitalizing everything into inventory, then you're also going to have this kind of giant ending inventory number. And so you're going to have kind of more of a deferral of a lot of these expenses. It's going to slow a lot of your expenses.
And what's your take on what the IRS said in Denver about 471C?
So I'm not sure I know what they said in Denver. I know the regulations. Well, before I talk about the regulations, so 263A is a code section that is also related to inventory that requires a lot more cost to be capitalized into inventory, and it's got some flush language that says, but if the cost isn't deductible, you don't get to capitalize it into inventory. So that prevents us from taking non-deductible expenses and then trying to recover them. And so, so 263A is out the window for cannabis companies. And so 471C doesn't include that same kind of language. In the regulations, they added that into, the regulations, but the section 471C was written after 263A. If that provision is required to make that, to prevent a taxpayer from capitalizing those costs into inventory, then Congress knew or should have known that that requirement would or should have been included in 471C. And also the way that 471C is written, it says 471A shall not apply. 471A is what gives the Treasury the right to determine whether or not taxpayers' inventory method clearly reflects income. So arguably, 471C took away their ability to make these regulations about your method under 471C. So I think there's a lot of problems with those regs. And anecdotally, I've heard that people who are getting audited on 471C are getting no change audits. I personally haven't had that situation with a taxpayer or even had a taxpayer get audited on 471C. But I think that's, you know, to the extent that you know, take these as truth, I think that's certainly, you know, good news for.
Yeah,
for the
just to
next-
confirm, I was just double checking. Yeah, what they said is they interpret 471C narrowly, and they'll
Okay.
push back against attempts to sort of gut 280E by using 471C.
Yeah, I haven't seen that in practice, and with people I've talked to that are also in the space,
Okay, interesting.
you know, I haven't seen that, and other folks haven't seen that as well.
Charles, you want to add anything there?
Not to 471C, but I would go back to the choice of entity.
Sure, please.
And just to clarify, you know, if you're a C Corp, which many of cannabis operators are because they were able to protect their founders and investors from potential 280E audit exposure, essentially what the disconnect that will occur on a sale or exit transaction is the operators, founders are going to want to sell the stock. So there's only one level of tax in the lower capital gain treatment, but you will often find buyers, particularly private equity buyers, they want to buy the assets or otherwise acquire the business in a manner that allows them to get a basis step up, particularly if and when 280E there's descheduling, there'll be far more incentive for buyers to get a basis step up and to therefore amortize the acquisition. So the point is that sellers are going to want stock sales, buyers are going to want asset sales, and there's going to be a disconnect. And so if the company were operated as a pass-through, a limited liability company that's a partnership, it's one level of tax. So anyways, then there will be the question, well, I anticipate an exit, whatever, 3, 5, 7-year horizon. Do I want to change from a C Corp to an LLC? And that change would typically be taxable. So, I mean, that's kind of the landscape of.
Do you think, you know, I guess just for like someone who's like, suppose someone's starting a new company today, right? I mean, the approach I've seen people do is we'll just do an LLC. And if this rescheduling doesn't come to fruition, then we'll check the box in the future to be taxed as a corporation. Because that gives us the maximum flexibility. Are you seeing people?
Absolutely. Or it gets complicated, or a hybrid structure where there is both a C Corp operator and an LLC holding company, the intent of which is, for lack of a better term, to modulate what happens upon an exit. So the C Corp operates under 280E. It protects the founders and investors from potential audits, but there's a secondary company that may hold different assets and may have a greater percentage of proceeds from a sale, and that other entity is the pass-through. I mean, there are other means to ameliorate or reduce the burden from 280E and double taxation. But that's kind of the
And I'll just,
middle ground.
yeah, I'll just throw in my experience in terms of like entity choice has been that, at least in the past, I mean, it's less so the case now, but during the heyday of the Canadian listed companies buying up companies, everyone wanted to be a C Corp at the time, because then you could do a 368.
Tax-free
Where,
reorg, yeah.
so there are some deals where it's you know, it's a tax-free reorg, but the company needs to be a corporation. And at that time, everyone was wondering, well, how long would it take to convert my LLC to a corp so I could do one of these deals? So I guess what it sounds like is to sort of maximize the value in an exit, you almost need to game out who do you think the likely buyers are going to be in let's call it 2025, 2026. You know, are the Canadian public companies going to rip and have the share prices that allow them to use their stock as consideration for deals? Or is private equity going to finally get comfortable enough with Schedule 3 that they say, hey, here's an inefficient industry that we can roll up, which, nobody's really been able to pull off to date. Can we go to the next slide, please? I'm just gonna, this is kind of technical stuff. So I'm gonna go to the questions here. Of course, if you want to talk about basis retention, because I know this is the issue you were talking about earlier, Charles, which is if it flips June 1, 2025, how are you addressing past basis questions?
Correct. Say, for example, you just comply in the sense of you say, okay, I'm not going to fight the IRS on prior year periods with respect to 280E. So I'm going to, as soon as descheduling occurs, thankfully 280 is gone away. The question is, well, what happens to all of the deductions in the past that were not permitted? And one argument is, well, wait a minute. If the IRS prohibited the deductions via 280E, then I, as an operator, have a much higher tax basis in my assets. So those deductions didn't depreciate my tax basis. So for example, when I go to sell, I have a huge tax basis that would give me the ability to defer or reduce some of the capital gains on the sale. And that's an open question as well. Now, the CBS Corp case saying is, hey, if there's deductions that were disallowed, then the basis should still remain. But that's an open question.
Oh, sorry.
Go ahead, Jesse.
Oh, no, I was just following up on that. I mean, even the code section itself that requires adjustment of basis, it says you have to adjust it for depreciation allowed or allowable. So if it was neither allowed nor allowable under 280E, I mean, really, we should never have reduced our basis by, disallowed depreciation. And I think even aside from depreciation, you could take this a step further. If you think about, let's step away from cannabis for a minute. If I go get a haircut, right? So my haircut's not, it's not deductible because it's a personal expense and it's disallowed under section 262, right? Not 280E. But if I get a refund on that haircut, I might not realize that I have basis in that haircut, but I have basis in that haircut, right? So if I get my $25 back, I'm not going to get taxed on that $25 because I had basis in that haircut. So why could not the same thing be said about all of these other things we spent in carrying out our cannabis business that was disallowed by 280E, right? If I would have been able to deduct that haircut, maybe because I'm an actor or something, right? Then if I deducted it, the tax benefit rule would say I do have to pick it up in income, right? So if all these prior cannabis expenses are like a personal expense that I didn't get to deduct, and the tax benefit rule would not apply to bring it back into income, it seems like I would still have basis in those items. And the question is, how can I recover that basis? And so when I sell the whole company, do I have inside of my company basis in all of these expenditures that I've spent over time and was not able to either recover through a deduction or capitalize into inventory or 471? If I wasn't able to capitalize them and recover them in some other way, do I have this basis sitting there that when I sell it, I can, reduce gross income by? So I think, like Charles said, it's an open question. I think it's an interesting question. Hasn't been resolved yet, but certainly worth.
In the case of, say, you had acquired a company, let's say, right? Is what Charles talked about earlier. You acquired a company and, because of 280E, you weren't able to amortize anything based on that acquisition. But depending on how this comes out, right? Could it be that post rescheduling, that essentially you now are able to You've sort of got an ability to amortize, reduce taxes on a go-forward basis.
I don't know. That's sort of the transition. Say, for example, you bought a company. Well, let's go back. When you buy a company that has goodwill under 197, you can amortize the goodwill over 15 years, which is actually not a bad arrangement. In the past, you couldn't amortize goodwill. But, you know, say I buy it for 15 million. Every year I get $1 million of deduction that I can offset operating income. It's not a bad arrangement. So say, for example, 5 years ago, you purchased a cannabis business for 15 million. For 5 years, you couldn't take the 1 million amortization deduction. What happens go forward? Can you take 1 million amortization deductions under 197 for the next 10 years? I don't know. I mean,
Or could you catch up on the ones you weren't allowed to take?
another question. I mean, does that mean you have 5 million of basis, and then you can take 1 million annual amortization deductions over the next 10 years? Or can you re-amortize the 15? That's certainly not contemplated by 197. So, I mean, to me, there's a lot of questions, and really, ideally, Congress would pass or authorize the Treasury to pass regulations that advise the landscape. What's going to happen with respect to this? But I don't have much confidence that that'll occur.
Yeah, I was gonna say I can't really see Congress passing something like that. Just to look, let's take some questions that we got. So, can you address effects on rescheduling? For example, will cannabis be sold in Walmart, CVS, etc.? If reschedule happens, is it federally legal then? So, pick this question because I can give you a good straight answer. So if it's Schedule 3, it's at least the state legal cannabis industry is not going to be compliant with federal law because the Schedule 3 substance, has to be sold as part of the medical system, right? So it'd have to be prescribed by a doctor, et cetera, et cetera. And that's really not the case for any of the products in the state legal industry. I mean, you hear some sort of doomsday people say, well, this means they're going to shut down all these state legal industries. I have very little concern about that because you could shut them down right now. It's Schedule 1. There's Schedule 3 is closer to legal, but no, it's not federally legal yet. And no, I don't think you'll see it in Walmart or CVS. And the only thing you'll see in those pharmacies are the drugs that have gone through FDA approval processes, or in states that sort of permit sales through pharmacies, but that's kind of a nuanced topic. All right. Would therefore the selling to it? No, so yeah, we get a question here. It's like talking about only traditional medical research and drug development would fall under Schedule 3. Therefore, state licensed cannabis companies would not be covered, so you'd still be subject to 280E. So no, that's not the case. 280E specifically mentions Schedule 1 or Schedule 2. So if the substance is moved to Schedule 3, you're out of 280E, regardless of whether you're sort of FDA approved or not, because it's based on the substance itself. So, you could illegally traffic a Schedule 3 substance today, right? You could sell ketamine illegally. I mean, plenty of people are selling ketamine illegally, and I don't think that would be subject to 280E because it's a Schedule 3 substance. You'd still be violating federal law, but you would not necessarily be subject to 280E. Let's see, what other questions? So we got a question about champs. Let's see. All right, I guess we also got a question. Wouldn't C Corps want to remain C Corps in order to take advantage of the qualified small business tax credit? And I think Charles addressed that. I mean, that's definitely a downside of switching to the LLC. I think you probably have to think about what's the tax advantage to acquirers you would get from being an LLC, and what percentage of that tax advantage do you think you'd be able to recoup as a higher purchase price versus the tax benefit of the qualified small business stock? That's my thought.
Yeah, absolutely. If you qualify for 1202, the qualified small business stock exception, so it's generally the greater of your basis or 10 million. And your basis is a fair market value measure. But in any event, yeah, I mean, you could be in a position where you don't want to flip to an LLC that's taxed as a pass-through. And when the potential private equity buyer comes around and says, I want to buy your assets so I can get a basis step up, you're just in a position to say, no, I have 1202 benefits. I can't risk losing it. And then you'll be in the world of negotiating. Potentially the buyer will say, well, I want to reduce the purchase price by the economic cost to me of not getting amortization deductions. And frankly, you'll probably be inclined to say fine, because if you have a significant exclusion of gain, that smaller purchase price, that the not paying tax is far more valuable. But those will be the types of questions and issues that will arise.
And I've got one last question for Sean. Has a judge been selected for the ALJ hearings? My understanding is they haven't.
No, not yet.
No judge. And what's the we don't know that, and that you think we'll hear in October? We don't have a set timeline, right?
We don't. We anticipate we'll hear in October, but it also wouldn't be out of the ordinary for these things to be delayed. And we do know some potential judges. Jason, I don't know if you want to add anything to that.
No, I mean, I think DEA has 4 ALJ judges. We expect probably they're going to pick the head judge. I forget his name, but that's kind of just what we expect, but not based on anything concrete. But we do certainly expect there to be at least some time given to the participants, and along with announcing participants should also be an announcement for the ALJ. And so, yeah, I think end of October, sometime at the beginning of November, unless this whole thing gets delayed, we should at least have a little more knowledge on that.
And just
Yeah.
so everyone knows, we're going to send out the slides to everyone. It has all our contact information in it. The video will get posted to YouTube, so you can rewatch it and rewatch it and rewatch it. And thanks everyone for joining.
Okay.
Yeah, Maroney, whoever just posted that. Also, just real quick, want to follow up. IRS will be unable to change 280E. That's a congressionally passed law, so that would actually have to come from Congress. So IRS won't have anything to do with even if they wanted to add marijuana back into 280E, they couldn't as a Schedule 3 drug.
I know there were a lot of questions on here, so definitely if we didn't get to yours, feel free to email any of us.